Hi, this is Kaery with Kaery Concealed in the Active Self-Protection Extra channel. This video is going to be a continuation of our series, the Use of Force Files and Trials series. This video is not what I was planning on doing, but y'all had some great questions in the comments. And so I thought I would address some of those questions now before we continue the series. So hopefully that'll help.
The Filster Enigma is a revolutionary holster chassis system that completely divorces your holster and gun from your clothing, giving you unprecedented concealment whether in sweatpants or formal wear. It attaches to your AIWB holster via the wing and allows incredible flexibility for your concealed carry. Get yours at the link below.
So just as a reminder, this case is about, that we're talking about a use of force incident that involved a young woman who was in her home, her own home, sleeping in her own bed. Her two young children were also home at the time. And this was a unexpected, unwelcome, unknown home invasion in the middle of the night. And the individual that attacked the homeowner weighed 152 pounds more than she did. And it was a man attacking a woman. So that's just a reminder about the details of the case. And the charges, after 2 years and after a super long and thick expert witness report and a lot of work by the attorneys, by Miss Brooks Wilson attorneys, the charges were actually dropped. The case was dismissed. So some of the comments, a lot of people commented that there's more to this case than we know. And there are some facts of the case that I haven't shared. They're not germane to whether or not it was a justified use of force, but it's not like there's some smoking gun somewhere, no pun intended, that would explain why she was charged. I don't know why she was criminally charged. It's certainly not something I expected would happen. And I think when we say things like, well, there's more to this than we know, or there's more information here than, there's got to be something in this evidence that explains why she was charged. I think it often makes us feel better to think that, because it helps us explain to ourselves, or it helps our brain make sense of why someone would be charged for using force in their own home when they're attacked in their own home, and an unprovoked attack. And so there's nothing about this case that is hidden somewhere. I request full discovery. Any case I accept, I will only accept it if the people I'm working with agree to give me full discovery. And I do review every minute of every video that I'm given as part of discovery. I read every page I'm given, and I don't mean just scan it, but I read it. Oftentimes I'm watching the videos more than once, especially the important parts. And the body-worn camera video, this case doesn't involve 19 hours of body-worn camera video, but there's quite a bit of it. And I read over 600 pages of medical records for this case. So I have all of discovery for this case. So I know as much as one can possibly know about the case. I know as much as I can. I even often will ask for things, not always, but sometimes in a case, I will ask for additional discovery materials, or additional materials that aren't in discovery. And an example would be calls for service. If it's like a domestic violence type situation, or two individuals that have maybe known each other, I might ask for the calls for service that gives me for those persons' names, or for those addresses where the incident happened. And it just can sometimes give me a little bit of information about what's happened in the past. In this case, the calls for service, when I received those, that was very helpful. And I'll explain that in another video. So there isn't more to this case that would explain why she was charged. Another question, or another comment people are making, well, I'm so thankful I don't live in Washington State. This is not a state issue, and I assure you of that. Again, I think it makes us feel better when we think, oh, she was charged because she lives in Washington State. That's not the case. The political climate in the county in which she was charged is it's quite pro-gun, to be quite honest. and lots of firearm owners live in the county. But I have colleagues across, yet she was still charged, right? I have colleagues across the country who, in states like Texas, Arizona, Florida, who are dealing with things like this as well. People that are being charged for protecting themselves, even in their own homes. So it's not just a Washington thing. I know it makes us feel better to think that, well, it's just because the state had happened and that's why she was criminally charged. I believe that this is happening. People are being charged. I have another case that's very similar to this that hasn't been fully adjudicated yet, but I have another case that's very similar to this. And in my opinion, there are 4 to 5 main reasons why I'm seeing it happen. And these are just my opinion. And I've talked to some colleagues and they tend to agree with me on several of these. So it's the first one is in medium to large metropolitan areas, the law enforcement agencies are spread so thin, especially their investigative resources. There's little time for a robust, exhaustive investigation like used to in past times. There's also a lack of understanding, in my experience, on the part of the investigating officers about, and that's not just for this case, this is for a number of cases I've had, about exactly what the use of force standards are and how they apply. Sometimes officers will think that the standard use of force standards are different for police officers than they are for private citizens. But when we get right down to ability, opportunity, and jeopardy, and the immediacy of a threat, those standards are the same, whether you're a police officer on duty or off duty, or a security guard on duty or off duty, or a private citizen out and about your normal life at home or out in public. So I think that it leads to confusion. I also think for police officers, there are many unmeritorious lawsuits, or not lawsuits, sorry, well, lawsuits too, but unmeritorious criminal charges filed against police officers involved in officer involved shootings. Not all the time, but sometimes it happens. Why does that happen? That's got to be particularly confusing for officers because, especially if they were there and they saw the incident happen, or they are intimately involved with the facts of the case, and they can't understand why this officer that used force in a justifiable manner, let's say that's a case that involves a justified use of force by a police officer, they can't understand why the officer is criminally charged. It doesn't make sense why they're criminally charged. And sometimes it doesn't make sense to any of us why an officer is charged in a case. Sometimes I think it can be for political reasons, or all kinds of things behind the scenes that we don't necessarily understand. But that's got to be particularly confusing for police officers that are investigating uses of force among private citizens when one of their colleagues is criminally charged in an officer involved shooting when the discovery shows that it was a justified use of force. So I think that's got to be confusing. A second reason that I think that these cases are charged is because the prosecutor offices are so overworked as well. True self-defense cases are extremely rare, extremely rare, extremely rare. But there are false claims made all the time. And those are the claims that the prosecutor's offices and, frankly, criminal defense attorneys are frequently seeing. Far more of those they're seeing than an actual justified use of force. So when a prosecutor's office is overworked, when they have too big of a caseload for each prosecutor, when do they have time to dig into the facts of a case? Well, in some cases I've had, in this case, for example, there were either 3 or 4 different prosecutors assigned to this case during the span of the almost 3 years that it took for this case to be resolved. So imagine if each one of those 3 or 4 prosecutors spent the time to go through all of the discovery for the case each time, they got the case. That's an incredible amount of time. So when does the prosecutor actually dig into the facts of a case? Often it's when trial's coming close. And oftentimes trial can be pushed out for a while for a lot of reasons. Sometimes it's scheduling, sometimes it's just the investigation takes time, especially getting things back from state crime labs, that sort of thing. So when a case is assigned and a prosecutor has, uh, and a case has 4 different prosecutors over a 3-year period of time, it if the first prosecutor might have looked in the facts of this case early on, they might have been able to see for themselves that it was a justified use of force, maybe not. The other thing too is we often think that the people that know the most about self-defense and uses of force are attorneys, right? They went to law school. But as Mr. John has talked about on this channel many, many times, the amount of time in law school spent on self-defense and claims of self-defense is incredibly minimal compared to the rest of the 3 years. And why is that? Well, because there's so many different types of law that they have to cover in law schools, and the percentage of cases that are truly self-defense are so minuscule compared to all the other types of law that attorneys are expected to learn about and know. So I understand why they don't spend a lot of time on it, but that can lead to some misinformation and some confusion. Let's go back to the part about the false claims of self-defense. That's one thing that is incredibly common. Not only is that common, and not only are prosecutor offices inundated with that, but so are criminal defense attorneys, and so are police officers. They hear false claims all the time. And so because of that, I wanted to address that in my report. So at the very end of the report, there's a section called specialist opinion, and that's where I use elements of discovery and say, from discovery, this happened, and that's in support of blah, blah, blah. So the very first paragraph of that specialist opinion section reads this: detectives, prosecutors, and judges are continually bombarded with fabricated or false claims of self-defense by people whose uses of force fell outside the use of force standards. Often these fabricated or false self-defense claims are made because the individuals mistakenly believe they acted in self-defense, or because they don't want to be called to account for their actions and criminally charged. Having to deal with a never-ending flow of mistaken or fabricated self-defense claims can be the breeding ground for negative perceptions and even apathetic feelings towards self-defense claims, and understandably so when innocent people suffer. Unfortunately, false or fabricated claims of self-defense often emerge in the same exact manner as do legitimate claims of self-defense. And as such, it's imperative that in the analysis of self-defense claims, we consider the totality of the facts and circumstances that led up to and surrounded the defender at the time they made the decision to apply force. So those false claims can really cause confusion and wreak havoc for people. So that's part 1 of answering some of your questions about this case. And next week we'll cover part 2, and that's where we'll finish up answering some of these questions and 2 more reasons why I think that these cases are often charged. And then in the next video, I will also read to you the purpose section from the report, which is brief. It's just 2.5 pages. And that will give you all of the facts and circumstances of this case that were germane to the decision that I made, or to my opinion about the case. So come on back next week and we'll see you then.